in a pending suit filed by the respondents plaintiffs, the petitioners defendants made an application under Order 7 Rule 11 of CPC raising certain objections therein and contending that the suit be dismissed as it is threshold on the basis of objections so raised by them in the said application. It is this application which came to be rejected by the learned trial judge on the ground that these objections can be raised in the written statement. It is against this order, the defendants have come up in this revision. The question has been examined by their lordships of Honorable Supreme Court in the case of Salim Bhai and others versus State of Maharashtra and others (2003) 1 SCC 557 and held that the trial court can exercise the power under Order 7 Rule 11 CPC at any stage of the suit before registering the plaint or after issuing summons to the defendant at any time before conclusion of trial. For the purpose of deciding an application under Order 7 Rule 11 CPC, the averments in the plaint should be German, the pleas taken by the defendants in written statement would be wholly irrelevant at that stage. Therefore, a direction to file the written statement without deciding the application under Order 7 Rule 11 CPC cannot be procedural irregularity touching the exercise of jurisdiction by the trial court. The apex court directed that the case be remitted back to the trial court, deciding the application under Order 7 Rule 11 CPC on the basis of averments in the plaint, after affording an opportunity of being heard to the parties in accordance with law. The only thing that this court can do is to set aside the order and direct the trial court to decide the application filed under Order 7 Rule 11 CPC on its own merits and decide the issue so raised therein strictly in accordance with law without compelling the defendants to file written statement. The law laid down by the apex court in the case of Salim Bhai Supra is binding upon all the courts in the country under Article 141 of the Constitution of India and hence need to allow this revision and set aside the impugned order. Learned counsel for the respondents submits that no direction can be given by this court while hearing the revision under section 115 of CPC because according to him, the revision is not maintainable in view of recent amendment. Once the point is settled by the law of land and if it is found that the view taken by the trial court is not in accordance with law, so laid down, there are no fetters on the power of the High Court in exercising the powers. Indeed, non-exercise of powers would amount to perpetuating the illegality committed by the trial court, whereas exercising the powers would follow the law laid by the Supreme Court in the case of Salim Bhai Supra. The objection raised by the respondents is on technical side, full stop. The High Court, being the court of supervisory jurisdiction over the trial court, comma, can always pass orders to maintain the judicial dispute, full stop. Accordingly, comma, in view of the aforesaid limited discussion, comma, this revision succeeds and is hereby allowed, full stop. The impugned order is set aside, full stop. It is directed that the trial court will decide the application made by the defendants under Order 7, Rule 11 CPC in accordance with law on its own merits, preferably within a period of 3 months from today, full stop. The registry to send record back forthwith, full stop, over. फ्रेंड्स, कैसा लगा ये बताइएगा मुझे मैं कमेंट में, और इसे ज़्यादा से ज़्यादा लाइक शेयर कीजिएगा. इसकी स्पीड मैं टाइटल में इसके लिख दूंगा. और नए यूज़र्स प्लीज़ इसे सब्सक्राइब करें, उसके बाद बेल आइकन दबाएं ताकि आपको अपडेशन मिले डिक्टेशंस की, आउटलाइंस की. और फ्रेंड्स, कैसा मतलब जैसा भी कम इसका रिस्पांस आपको मिलेगा या रिक्वायरमेंट जो भी हो आप मुझे बताइएगा, तो मैं उसके अकॉर्डिंग जल्दी से वीडियो बना के भेजूँगा. थैंक यू.